Welcome to our panel on human rights and the climate crisis, the critical role of lawyers and judges in securing the right to a healthy environment. Greetings also to our coordinators of the thematic human rights group, Deborah and Stephen, who organized the event. A warm welcome to our panelists. We are delighted to have with us April Williamson, Senior Legal Associate at the Climate Litigation Network in London, Michael Wilson, Retired Associate Justice of the Hawaii Supreme Court, Anjana Ramanathan, Assistant Professor at Jindal Global Law School in Sonipat, India, and also Lucy Maxwell, co-director of the Climate Litigation Network. Now, a little bit of housekeeping. We will proceed as follows. First, our speakers will give a presentation of around 15 minutes, and then the panelists have an opportunity to respond and comment on the issues discussed. After that, we will open the floor to our global audience. April will begin with an introduction to climate change and related litigation. She will discuss the famous Urgenda case and its implication and some more recent cases before the European Court of Human Rights. Michael will discuss his work at the Supreme Court of Hawaii and recent US cases in Montana and Juliana. And Anjana will highlight cases from the Global South, including cases from Brazil, India, and Pakistan. And Lucy will be available for comments later on with questions to answer questions from the floor. Please make sure you are all muted and feel free to enter your questions in the chat during the presentations. And yeah, I think this is it for the moment. Please make sure, as I said before, to mute your audio systems. And I will now hand over to our first panelist, April Williamson. April, you have the floor.
Thank you very much, Thomas. Please bear with me while I open up my slides. Okay. Well, as Thomas kindly introduced me, my name's April Williamson. I am a Senior Legal Associate at the Climate Litigation Network. I'm here today with my colleague Lucy Maxwell, who's the co-director. As Thomas mentioned, we're going to be covering climate change litigation and how this relates to human rights with a bit of a case study on the Urgenda case. So just to kick things off, about the Climate Litigation Network, we are a project of the Urgenda Foundation, which is a Dutch charity. Urgenda's vision is a fast transition towards a sustainable society, and it has a focus on a transition towards a circular economy. The Urgenda Foundation actually won a landmark climate case against the Dutch government, which I'm going to cover in a bit more detail later in the presentation. And Urgenda set up the Climate Litigation Network in order to support national partners to bring framework climate cases. And what I mean by that are legal cases that challenge the overall level of ambition of a government's response to climate change or a government's failure to implement measures that are adequate in order to achieve their ambitions. So I thought that I would start off the session as a bit of an introduction to this panel, very simply going back all the way to the basics. What is climate change? What are the consequences and what are governments doing about it? So in terms of the science, as you probably all know, but I thought we'd just start out with the very, very basics. When fossil fuels are burnt, they release greenhouse gases such as carbon dioxide. And when greenhouse gases accumulate in the atmosphere, it creates a warming effect across the globe. Because heat gets, of course, trapped by the sun. And since pre-industrial times, the average temperature of the globe has actually already risen by 1.1 degrees Celsius. And while this doesn't sound like a lot, temperature change varies quite considerably depending on where in the world you are. So temperature rise has been much higher towards the poles and in higher altitudes. And as an example, the Arctic has actually already warmed about 3 degrees since 1980 and is warming about 4 times faster than the rest of the world. And these small changes in temperature can actually lead to massive knock-on effects. This can include things like extreme weather events. So you will have seen in the news things like extreme heat, droughts, storms, flooding, landslides. And of course, sea level rise is also something that's an inevitable consequence of global warming, because ice in the Arctic and Antarctic regions are melting. Changes in regional temperature can also have really big consequences for animal and plant growth and their breeding cycles, which could have knock-on impacts on ecological stability and food security. And all of these changes can have really profound impacts on human health. So you can see a kind of overview here from the Wellcome Trust in terms of how climate impacts can start relating to health risks. Probably one of the most obvious types of impacts is extreme weather events, because they have direct impacts on human health and property. And over time, many areas of the world may actually become less habitable as changes to the climate and weather cycles make food and water security more tenuous. And in many countries, such as low-lying islands or coastal areas, may actually become uninhabitable because they become inundated due to rising sea levels. So in terms of what governments are doing about this, governments have known about climate change and its impact for many decades. The United Nations Framework Convention on Climate Change was agreed in 1992, so that's over 30 years ago, and almost every country in the world is party. And under this agreement, almost every government in the world has agreed to stabilize greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. So what does this mean? Since that agreement was signed, climate science has come a very long way, and the consensus is that limiting temperature rise to 1.5 degrees Celsius will avoid the worst impacts of climate change. And this scientific consensus has been formalized in the binding objective under the Paris Agreement, which was signed in 2015, and that's to keep temperature rise to well below 2 degrees, pursuing efforts to limit temperature rise to 1.5 degrees. So I hope that's kind of a whirlwind introduction, so we can dive into climate litigation. So why are communities taking cases to courts? I think that it's quite obvious from the news, for example, that we're living through a climate emergency. Over 2,000 government bodies in more than 40 countries have actually declared a climate emergency already. 2023 is actually on track to be the warmest year ever recorded, and the impacts of this have been really clear over the news in the last 10 to 12 months. Over this year alone, I think we've seen news articles covering devastating fires in the US, Canada, and Europe. There's been cyclones in the US, Asia, and Africa, and record-breaking heat waves across the world. And of course, also severe flooding has been happening in many countries. And this has had a huge impact on communities, obviously because people have been losing their lives, but also their homes and potentially their livelihoods as a consequence of all of these climate change-induced impacts. So despite there being international agreements in place, national policies are not actually adequate to limit temperature rise to safe levels. According to the United Nations, policies that are already in place with no additional action are projected to result in global warming of about 2.8 degrees. And if all of the pledges that have been made to date are implemented, this could mean warming of about 2.4 degrees Celsius. And as you can imagine, that's much higher than the amounts that have been identified by prevailing science to ensure that we avoid the worst impacts of climate change. So a report, for example, by the UN Environment Programme actually described government action as woefully insufficient. And to kind of illustrate this, UN agencies have projected that global emissions across the world are actually set to increase by 2030, when science has shown that they need to be reduced by about half by this time. So in light of this, there's been a huge number of campaigns by individuals, communities, young people, and they've really proliferated since the Paris Agreement was signed. One of the most famous examples, of course, is Fridays for Future, which is strikes led by school children. And there have now been Fridays for Future strikes in over 150 countries and millions of school children taking part. And climate litigation as a movement has started in the 2000s, but has really developed over the last 10 years or so. And the reason for this is that communities are turning to the courts because they're considered a last resort to try and compel governments to take action when other types of engagement haven't been successful. So to cover the Urgenda case as a bit of a case study, this case was brought by the Urgenda Foundation and just under 900 Dutch citizens against the Dutch government. It is the first case in the world where a government was ordered to reduce its emissions by an absolute minimum amount. In this case, it was 25% by 2020. And it was the first time that a court had provided a detailed account of how human rights obligations need to be upheld and delivered by states in the context of climate change mitigation. So this is really important and is a factor why the Urgenda case has kind of been used as a case study and a precedent for many other cases that have been taken around the world. In terms of the legal basis of the judgment, the District Court of The Hague ordered the Dutch state to reduce its greenhouse gas emissions by a minimum of 25% below 1990 levels by 2020. It essentially found the government's existing pledge to reduce its emissions, which was, so the Dutch government had originally agreed already to reduce its emissions by 17%, and the court decided that this was not sufficient to be able to meet the Netherlands' obligations under international law and to limit temperature rise to 2 degrees. The court actually found that this was a violation of the state's duty of care under the Dutch Civil Code. So this case actually went up to the Hague Court of Appeal and then the Dutch Supreme Court. And these two higher courts found that the Dutch government had actually also contravened its obligations under the European Convention of Human Rights to protect the right to life and the right to private and family life. So in 2019, the Supreme Court upheld the lower court's decisions and essentially found that the state's conduct was unlawful. So I thought it would be helpful here to give a bit of an overview of the types of human rights that are engaged in climate-related cases. There are a range of rights protected under national constitution and national law, as well as international and regional human rights agreements that might be engaged due to a lack of climate action on the part of the government. So these are 4 of probably some of the most common, but are not all of the rights that we could potentially cover today. This is just an introduction. So the first 2 that I would mention is the right to life and the right to private and family life. These 2 rights are protected under every major international and regional human rights convention. So we can see here in the purple boxes, these are the International Convention for Civil and Political Rights, the European Convention on Human Rights, the American Convention on Human Rights, and the African Charter of Human and People's Rights. The right to life, I think, is quite obviously engaged if, for example, climate impacts like extreme weather events threaten someone's life or well-being. The right to private and family life is quite a broad right that covers the right for people to live independently, with dignity, and without government interference. So a good example is that this right could be engaged if people have to move away from their homes due to issues like sea level rise or natural disasters, or if their health or their livelihoods are impacted by environmental conditions or other impacts from climate. The right to culture is protected under the International Convention on Civil and Political Rights and may also be protected under national law. This is designed to protect cultural traditions of ethnic, linguistic, or minority groups. So, for example, there are many cultures where traditions are tied to specific locations, and those could eventually become unsafe or even cease to exist due to impacts such as sea level rise. And then finally, we have here the right to a healthy environment. So far, this is only enshrined in the African Charter, but it has recently been recognized by the UN General Assembly as a universal right. It's also a very common component under national constitutions and national laws. And as you can imagine, it could be engaged if local conditions become unsafe or if they deteriorate due to climate change. And there's a very inherent link here between the right to a healthy environment and all 3 of the other rights. So just to give you an example of how human rights cases are developing in Europe, I thought I would cover 3 cases which most environmental litigators are keeping a close eye on. These cases here, Carême v. France, Clima Signorinen in Switzerland, and Duarte Agostinho and others versus Portugal and 32 other states, are being heard in the Grand Chamber of the European Court of Human Rights. So the European Court has recognized the importance of these cases and realized how significant they are because they've been accelerated and are going to be heard by a full panel of 17 judges. This is a very tiny proportion of cases that get treated this way, which means that the court is taking this very seriously and are expecting for these to form essentially a precedent for other human rights cases across Europe. Hearings on these cases were held in March and September this year, and decisions are expected next year in 2024. And the outcome could have a really major influence on how human rights cases are designed and adjudicated upon across Europe, and could potentially have impacts abroad because many human rights courts, tribunals, and other bodies look to regional courts to help inform their own jurisprudence. So to give you a kind of overview of what these cases are about, in Carême, the former mayor of the region of Grand Centre, who was also a resident there, asked the French Council of State to cancel the government's refusal to take additional measures to meet France's objective of achieving a 40% reduction in emissions by 2030. This case was actually successful, but the Carême, the individual mayor's application, was refused because the French courts thought that he wasn't individually impacted enough to bring the case. So this case is now going to be heard to determine whether his rights individually, in terms of the right to life and the right to family and private life, were engaged by the state's failure to take additional climate mitigation measures. In Clima Signorinen, the case was brought by an association of senior Swiss women who claimed that the state had violated their rights under both the Swiss Constitution and the European Convention on Human Rights. The rights that they said were engaged were the right to life under the Constitution, the right to sustainability and environmental protection, and then under the European Convention of Human Rights, the right to life and the right to private and family life. They were essentially arguing that their demographic is especially vulnerable to heat waves, which are expected to become more frequent and severe due to climate change. And they argued that the government's 2020 and 2030 targets were not sufficient to limit temperature rise to safe levels, and that being 1.5 degrees or 2 degrees. And then finally, the Agostinho case. The applicants are Portuguese nationals aged between 10 and 23. So this is fundamentally a case being brought by youths. They have argued that the 33 European states that they've brought the case against are failing to comply with their obligations under the European Convention, again, in respect of the right to life and the right to private and family life. And they also are alleging that the states have violated the duty to prohibit discrimination, arguing that global warming is going to affect the younger generation particularly badly, and that given their age, the interference with their rights is going to be greater than those of older generations. So some very similar themes across all three cases, but also quite subtle differences in terms of the types of plaintiffs and the details of exactly what they're arguing. And then finally, which I hope is going to set the scene for the other panelists, is how is climate litigation developing around the world? So the Sabin Center has been compiling a database of climate litigation. And as you can see here, there's a huge amount of cases that are happening around the world. And by 2023, they had registered over 2,300 cases which concern climate change. And around 190 of those were filed in a single year between June 2022 and June 2023. So this is really an emerging area of law. It's really gaining momentum. I mean, there's been many positive outcomes already. So I understand my co-panelist Anjana is going to be focusing shortly on cases in the Global South, but just to give you a bit of a taster in terms of what can courts do to help solve the climate crisis, out of the cases that have already had decisions issued, about 50% of those have had direct judicial outcomes that have been categorized as favorable to climate action, which is a fantastic outcome. Some of those cases have led to pretty well documented changes in policy. And even cases that have been unsuccessful have led to pretty significant indirect outcomes outside of the courtroom. So for example, many of these cases have associated campaigns, and the idea is that in addition to trying to get a legally binding outcome, they're also trying to raise public awareness and push political decision makers to adopt more ambitious policies. So binding positive decisions have been made in courts all over the world. And just as an example, in Europe, courts have ordered governments to take more stringent action and improve their emissions reductions targets. They've ordered them to adopt further emissions mitigation measures in order to meet their existing targets. And they've been ordered to disclose more information about how targets are going to be met. And successful cases have been decided in major economies. So in Europe, again, we've had successful cases in the Netherlands, of course, with the Urgenda case study I just mentioned, the UK, Ireland, Germany, France, and Belgium. And of course, there's hundreds of cases that are still pending, and there are more being filed every year. So overall, I hope that this has been a bit of a taster of how litigation can be used as one of the many tools that can be used to try and achieve higher ambition at the national level. And with all of the positive work that's going on, I at least am quite hopeful that together we can try and find a solution to this. But thank you for your time, and I'll pass back over to Thomas now for the other panelists to give their presentations.
Thank you so much, April. That was a wonderful presentation, very insightful, and really setting the stage also for the other panelists. Thank you so much. And I will now call on Michael to set up his screen if you want to, and then the floor is yours.
Aloha, everybody. Let me go ahead and start my slide presentation here so that we can begin. I will share it and say aloha. So I am speaking to you from Hawaii early in the morning. And April, I have to first of all express my reverence for the Urgenda case, which I have been working with for well over a decade now. And I will speak about, as you've set the stage, the situation for judges. And I would use the word emergency to make sure and set the stage in what I hope will be an exercise in realism today. And we'll be talking about the role of judges in solving the climate emergency and apex decisions that have to do with whether this is going to take place in the grassroots level of the courts. Also, the final stand and the network during this phase that we have before perhaps there's a collapse of the rule of law. And I always am interested in speaking about the tiger, my favorite animal in the world, if I'm giving a presentation in India. It's with a great deal of pressure that I give this presentation because my revered colleague and brother, Stephen Marks, has arranged this and put this together. And he was with me when, along with a brave group of adventurers, we found the wild tiger in India. So I do speak to you from the most remote landmass on Earth, which will explain a bit about why Hawaii has become the climate litigation center for the United States, and I would submit within the last month, the climate litigation center for the world. I was just a month ago at my home in Sonipat at Jindal Global Law School. I miss India. They are our partner, but in thinking about where I am and where I come from a psychological point of view as a judge and a citizen of the earth, I would say that we have a partnership with India because we have a commitment to nature. By we, I'm talking about the judiciary, not just a commitment to the human part of the planet. And this is the nature of Hawaii. This is where I grew up. This is the most powerful outdoor experience I've ever had. It's the beach on Kauai called Kalalau, and it will be gone in about 30 years at present levels of global warming. These are the treasures of Hawaii, and they'll either disappear or be reduced in population. The whales and the dolphins are smart and can move. Maybe there'll be some left when the earth heats up to 1.5 degrees, but our birds will certainly be gone. So the context of my presentation and the presentation that I've been giving virtually 3 times a week for the last year or so can be encapsulated, summarized, focused from a judge's point of view on the nature of the emergency. In the law, emergency is used quite a bit to define the responsibilities of judges, but this is the greatest emergency humanity has ever faced. It's a sui generis emergency, unlike any other emergency, because the impending solution horizon, the amount of time to solve the problem, is limited. It's the most important issue humanity has faced, and unfortunately, the time period in which to make the changes that April alluded to might be. So with that in mind, let's be specific, because judges can't just be involved in academic exercises. They, of course, are in the trenches and having to define facts and apply a lot of those facts. And in Hawaii, we are very much aware of the 1.5 degree limit that April spoke about. In other parts of our country, there is a growing movement of judges and academicians to justify 2 degrees, which is quite a threat to Hawaii, because at 1.5 degrees, we will be devastated. However, this is where we're going during our children's lifetime, which would mean that destabilization, not just of the world economy, but the rule of law as well. So my point from a judge's point of view is, if you're going to tell the truth about the law, we have to see that we're in an emergency and judges are in charge of solutions. It's always helpful to make the point of the Secretary General of the United Nations. It was made famously just within the last 12 months when he said, we are on a highway to climate hell with our foot still on the accelerator. And that hell is arriving in India and Hawaii faster than it is in most places. A dramatic example is we'll lose this beach. And while I'm on this slide, I want to make sure and invite all of you to Hawaii. It'd be a privilege to have protectors of our environment and informed climate litigators and climate specialists, but also it'd be great to show you the beach before it disappears. We'll lose this beach in about 30 or 40 years, our main beach. Okay, so I have 2 slides that are really important, I think, to get the focus of the situation that judges are facing with respect to the sui generis emergency. I can't show this slide too long because it has to do with the reality of what's really happening. April set up the circumstances that define the individual on the left. This is the David versus Goliath story that is an archetypal story throughout the world. And as you know, David, up against this very, very powerful warrior, Goliath, won with his slingshot. But after the Urgenda case, you could say David came on the scene. This small group of politically powerless people, namely future generations, came into the courts. And now it's the most important issue facing humanity. But in the courts, this is what's happening every single day, every moment. You have a mismatch. Courts are used to mismatches, and that has led to incredible injustices. For example, in the agricultural era in the United States, we had a mismatch when the agricultural industry needed slaves. And when the issue came before the United States Supreme Court as to whether slavery was constitutional, the courts, in committing what has been called atrocity law, found that slavery was constitutional in the United States. The buying and selling of Black people and their children was constitutional. The power imbalance that's taking place now is something that political scientists are doing their best to try to describe, where you have new empires of wealth the world has never seen, namely the fossil fuel industry. After the pandemic, there were record profits. For example, Exxon Mobil profits were $200 billion. And during that time, the level of their influence, which continues to be the same and is even increasing, meant that they also got subsidies, according to the International Energy Agency, of over $1 trillion. The same year, they made record profits of $200 billion. So on the right, you see the power of these special interests. So let's move into the reality of what's happening when you have future generations on David's side of this slide versus special interests as the world has never seen before. What's happening every single day in the courts in front of the men and women, mostly men, who have to deal with this. Judges have to decide now. They can't be on the sidelines. They're not allowed to just be the litigators where they bring the cases alleging a violation of the law. They have to make decisions. There is a group of judges that are starting to step forward, but to step forward in the political climate we're in now requires a grounding by a judge to strengthen their independence. And how do you ground yourself as a judge in order to gain strength to do the right thing? Look at your oath. Our oath is not to serve special interests. Our oath is to follow the law and achieve justice. As nebulous as that may sound, that is a theme throughout the world. We're supposed to achieve justice, which implies you're not supposed to give special preference based on political power, economic power. And this was a point that was made when I was in India with a team of judges from the United States about a month ago. And one of your great former justices of the Supreme Court spoke about how you can divide judges into two categories. Judges that focus on what's right, and that, of course, is to achieve justice, or judges that focus on power, that are sensitive to the government, sensitive to the power interest before them. Another way to put it is, judges, like many people, are concerned about their job. If you make a politically incorrect decision, you are headed towards a potential apex decision. So those are the two main concepts of this presentation: apex decision and the power imbalance that's in court every day before the judges. If the judges are going to be able to do their job and achieve justice in the midst of this power imbalance, you have to stick to the truth, stick to the facts, write it down so that when it's misinterpreted by special interests that have the economic might to hire marketing firms to misrepresent the judge's position, at least the judge has written it down. And prepare for the apex decision that will sacrifice your judicial career. Once you prepare yourself, when you begin as a judge, and I was just helping to train 50 judges in Asia 2 weeks ago in Jakarta, who are having to face these powerful concepts of applying the environmental rule of law and climate rights at a time when there is a huge amount of, or I guess you could say a historic amount of pressure on the judges, means that they have to prepare themselves at a psychological level. So when you start as a judge, you have to be ready to lose your job. Be ready for that very, very important decision where you decide perhaps against government, or you decide against the most powerful special interest in your community, and then you don't get to be reappointed as a judge, or you don't get to be reelected. But to do your job with respect to the climate issues, you've got to be prepared to make that apex decision, the one at the very top of your career that means you're going to lose your job because you do the right thing. Climate emergency law is the way judges see this and feel this, and it's in their gut. Climate law has a word that goes along with it: emergency, sui generis emergency. Do judges want to be dealing with emergencies? Do they want to be in the middle of this power imbalance? No, they're not trained for it. They don't come from that background. So it's really important for judges to ground themselves and prepare for the application of these concepts of the law. April, thank you so much for helping to apply the rule of law in a way that perhaps will be able to save our planet. But now, as you can see from having over 2,000 cases that have been filed, the legal principles are there. From the point of view of constitutional law, you've got the right to a clean and healthy environment, due process, right to life, public trust doctrine, and all of these concepts under constitutional law put in front of the judges the challenge of coming up with remedies, judicial remedies. To do it, there's got to be judicial independence, and there's got to be an appearance of judicial independence, no appearance of impropriety, because the strength of the rule of law right now depends on judges being willing to do things that are politically incorrect and make the apex decisions. This is an example of what happened in one of the cases we have that involved one of the most powerful special interests, namely our most important United States senator, combined with the University of Hawaii. And you could say that the establishment in Hawaii wanted this telescope to be built that was bringing in over $1 billion worth of value. And in the midst of the case being before the Supreme Court, I received an email from the agency that had granted the permit for the telescope. So in response to that, I issued an order, a public order, ordering that there be no more contact. And of course, I refused to read the email. But this is the reality that judges face. This is the reality that they face in applying any type of law. But now the common law is finally starting to become robust, at least in the state of Hawaii, where science is being applied with powerful facts to prove that the oil companies have committed fraud. In this case, it's being brought. And April, you will love to read this case. And I'm sure all of our participants will. This is the city and county of Honolulu versus the biggest oil companies in the world based on fraud. And what happened is our court refused to dismiss the case and found that the fraud case can proceed against these oil companies based on what theory? When they were selling their products, their oil products to our city and county of Honolulu, and saying there was no problem, they, in fact, the facts showed that they were trying to get patents, were getting patents so that they could mine the Arctic when the ice was melted to the point where they had access. They were also investing in strengthening their oil rigs because they knew that extreme weather events were coming. And now finally a jury is going to be able to decide that. And our juries are judges in Hawaii. They get to decide the level of fraud and the billions of dollars that potentially will have to be awarded. And so the rule of law will become operative in a powerful way. And it removes from judges, because judges are political, judges want to keep their job. It removes from the judges of the law the decision about the degree of injury and the degree of damages. So that's why it's a supernova. Supernova is the most powerful explosion in the universe. And that is just what happened in the last 3 weeks in Hawaii. This case is going to go before the judges of the facts. Jurors are judges of the facts in the United States. Our court said we decline to unduly limit Hawaii's ability to use its police powers to protect its citizens from alleged deceptive marketing. Very important statement about how the judge is not allowing the power of the oil companies to take away the police powers of our state.
Michael, can you wrap up, please?
Yes. I see I'm getting close to 15 minutes here. So this has become an extremely important issue throughout the United States just within the last week, where there's been an attack on our Chief Justice by the fossil fuel industry that's recently been described in the media to suggest that by previously speaking about environmental law, our Chief Justice became partial. And recently we've had a follow-up case, a case actually that just preceded our Helco case. And this is a case from Montana, in which they also found the fundamental constitutional right to protection of climate as a part of the environmental life support system. So, in conclusion, let me say that the rule of law is still robust. Unfortunately, it is not effective so far, nor have public policies been effective. And so the most important impact now that litigation can have is for the young people to continue to get organized, form their network, as they have in, for example, the final stand. It's in Sonipat at the Jindal Global Law School, a group of law students and young lawyers that are making a final stand and do not accept the future we're headed towards, where the earth will heat up beyond 1.5 degrees. And from the point of view of a judge that's been dealing with these issues for over a decade, I'm excited. It's an extremely historic and unprecedented application of the rule of law in a way that can protect minorities, protect women, protect young people. And as the litigation's been characterized by April as a kind of final stand or a last resort of the human society, a last resort going to their governments. It's an appropriate place for us to make the final stand in court if we have men and women that are judges that are willing to face apex decisions, exercise courage, and make decisions based on science and the law, and not make decisions based on their own self-interest or the interest of the rich and powerful in their courts. Aloha from Hawaii, which is the word that we use to recognize the beauty of the human spirit. As in India, we say namaste. It's a pleasure to have addressed you, and I look forward to the questions. Thank you.
Thank you so much for your powerful and passionate presentation. Insights really from a judge and from your experience as a judge. And I think so important in terms of what you highlighted, the readiness to lose your job is really there and hardly recognized, probably outside. So we have our third presentation here already ready to go. Anjana, you have the floor. You are still muted. The slides are visible. You are, but yeah, no, everything. We can hear you.
Yeah. So thank you so much for this opportunity to the HDCA Global Dialogue Week and everyone present here. And I won't take much time, and I will just straightly go and talk as to what I have to talk. We've heard April and we've heard Justice Michael speaking from a litigant's perspective, litigant's perspective, and also a judge's perspective. Now here I come, I bring a very academic perspective, summing up this entire sort of debate. I will not go into what is climate change litigation, what is climate change. April has done that for us, so I will go on to the region that I come from, the global south as we call it, and what is climate change litigation for us and how do we view it. I mean, the Sabine Center for Climate Change Law has put it very succinctly when it calls it, what are the cases that come into this definition? Cases that raise sort of material issues of law, fact, that relate to climate change mitigation, adaptation, or the science of climate change, and cases that raise issue of issues of these issues, and this forms the core of this area. But what we see in the global south is slightly different. We see that most cases that arise from the global south do not form part of this core of this definition, and that's why often most of the cases go unreported. Most of the cases sort of you can't see them on the statistics, like April showed or April mentioned also. The Sabine Center's latest 2023 report talks about 2180 cases, and you can see you can also see as to where the cases are arising from, which is the region that the cases are arising out of. And precisely this is our argument, that if we're out of the core of the definition, that does not mean that courts in the global south are not looking at climate change in the way they should be looking at. They're just looking at it in a different way because of their economic conditions, because of the, like Justice Michael pointed out, because of the situation of the rule of law, because of the fact of policy implementation. And it's actually baffling to see how many numbers of cases get highlighted in the global north and the global south. I'm not talking about a discrimination perspective. I'm simply speaking from an academic perspective, which sort of chooses not to see the cases that are on the periphery. That being my point, I will not delve on these statistics. I'm happy to share the slides so that you can see how many cases arise out of the entirety of the world. We also have to understand that climate change litigation is just not a global north phenomena. It is a phenomena that is engulfing the entire world. It is a phenomena that everybody has to be bothered about. It is, you have a blue whale also, being one of the litigants in one of the cases. You have children, you have indigenous women, you have women, you have so many varieties of litigants that are coming up. And how do you then sort of look at all these aspects? And when we noticed that when we were writing our paper, it's called the Chronicles, Climate Change Litigation Chronicles from the Global South, and looking at different countries. And this is one of the reasons, this is one of the things that we noticed, that, cases from the Global South do not get highlighted also because they speak about the right to a healthy environment from a fundamental rights perspective, from a domestic law perspective rather than an international law perspective, while also keeping in mind the international perspective. That is, whether you talk about the UNFCCC, whether you talk about the Paris Agreement, whether you talk about the responsibilities that each country has to undergo. Everything is there, but what is the problem? Before we started off the meeting, the question was asked about law and, where are we today, and what is what can be possibly the interventions. The possible interventions that any one of us can do, either as people who litigate or as people who judge the cases or as people who academically review them, to sort of see what are the robust practices that are evolving out of either jurisdictions, global north or global south, and cumulatively then make it as a strategy together for the world to look forward, whether it is Urgenda or whether it is Juliana, Montana, or any other cases. What are we learning from each other is the point that we want to stress upon. And if you the countries that we focused in our paper and for the betterment of this presentation is Brazil, India, Pakistan, Philippines, and South Africa. Why these countries? The Global South is not a home. It's a very it's not a uniform and a homogeneous group. It's a group that where the progressive realization of rights happens in different modes. Based on the economics of the country, based on the rule of law, based on the policy level at which, and more than the economics and the policy, based on the political climate that is there. This is perfectly the Goliath, the David and the Goliath situation. Only thing is that, in the biblical context, David won, but over here we do not know if David will even have the opportunity to throw the stones at Goliath, because the political climate becomes so difficult sometimes, wherein even though you have judges pronouncing judgments, even though you have litigants very creatively arguing in front of the court, when you talk about implementation, that's where the problem comes. And that's why cases from the Global South also do not get highlighted. And that's one thing that you can see like April said, again, sorry, April, to be quoting you again and again, but yeah, you started off, so, we're coming back to you again and again. So you had 3 waves of climate change litigation. And in the Global South, you saw the climate change litigation sort of increase post the 2015, post the year 2015, wherein, you had your this major case law that came out of Philippines, the carbon majors case law, which actually held 50 carbon emitting companies responsible. And the commission said that, hey, what you're doing is completely wrong, and you have every duty to sort of protect the environment rather than sort of just go and pollute it. That is something that was very, very seminal that came out of the Global South. And from then on, you can see that there are different principles that have been evolving. If you look at Brazil, you have these 2 cases, the Institute of Amazon Studies and the PSD. In fact, in both IEA and PSD, like I want to call it, you had there are developments even in 2023 where, again, it's a David and Goliath story where the court is ordering for a fundamental right to sort of have a right to clean environment. But what are your politicians doing? That's the question where it stands. And where does the buck stop? The buck stops. We do not know where the buck stops. The buck stops at political parties or at us that choose the political parties. And like also Justice Michael said that, you have people that are arguing very creatively, but these are countries, these are countries where human rights defenders get targeted every day. In India, you have this law called the UAPA, the Unlawful Activities Prevention Act. And I mean, like you question the government, you speak for your rights, and you're slapped with these cases. And how then do you combat if you are the litigant in this particular case? How then are you going to further take this area ahead? That is also a question that you and I have to think about. And in India, the thing to notice is, as the latest case law is Riddhima Pandey versus Union of India, wherein a 9-year-old girl is questioning the Supreme Court, is questioning the Goliath powers of our nation to actually bring up climate mitigation. What are the climate mitigation efforts that the Indian government is supposed to do? Because it's one of the core fundamentals of the public trust doctrine. And you can see this similarity even in Pakistan, where wherein you have this case called Maria Khan et al., which also again is by a young person questioning the government as to what the government is doing after being signatory to the Paris Agreement. What is the government doing? And the other case that came out from Pakistan was the Ashkar Leghari, which actually is one of the most important cases when you talk about climate change litigation in the Global South, because in Urgenda, the court actually struggled to pin the responsibility on the Dutch government. But in Ashkar Leghari, the court actually straightly put the responsibility on the Pakistani government and said that, hey, pull up your stock and sort of evolve principles. And you had policies that came out. And in comparison with, I already spoke about the Philippines case, the carbon majors case. So these two sort of form major jurisprudence in Philippines. And South Africa is also bringing about very, very important cases, jurisprudence to very important cases. But my major point is, I'm going a little back and forth, but I'm going to here where I talk about Urgenda, Leghari, and Juliana, which actually forms the crux of my presentation as to how much of an inroad. Yes, we understand that Urgenda is one of the major cornerstones of climate change litigation, but how much will an Urgenda work in a Global South perspective, where where we are developing economies and not developed nations. How much will it work? And in this sort of a background, how do you position yourself as a litigant? How do you position yourself as a judge? How do you position yourself as an academic who is looking at climate change? And I think one of the most, the need of the hour also as scholars in this field is for us to understand that climate change litigation is not just, you cannot divide it between the North and the South. It's a mixed bag. And the more we realize it's a mixed bag, the faster we're going to learn about each other's practices and form a knowledge base that is going to sort of, make more inroads to getting justice, even in a David and Goliath situation. After all, David won. And after all, we can see there are so many cases where the court has actually stood up. But what is lacking is implementation, and the Global South comes first in that. But, we also have principles that have come out of the Global South, the rights-based approach, transformative adjudication in South Africa. The Constitution talks about the transformative constitution. How do your rights come alive when you have nothing going again for you? Then you have the public trust doctrine, where the state is responsible for you. It's not something that has arrived from the Global South. It is from time immemorial. It's coming from the Roman era, where the state is actually the guardian of the citizen. Then the other thing is about enforcing existing laws, which Legari also lays down a strong link. And my conclusion will be, what if we are at the periphery? I don't think so. Just because we look at climate change issues from the periphery, our cases are not to be ignored. Our cases are to be well read within the definition of climate change litigation, and only then will you have a very intersectional view of climate change litigation. Unless otherwise, it will be a very skewed, narrow approach of the way the world views the climate change litigation. Thank you. Yeah.
Thank you so much, Anjana, for presenting us the views of the South and the importance of differentiating in the South and the particular challenges when it comes to implementation and the economics of the Global South. We will have now some time to respond, and it's a time for the presenters to comment on each other's presentations. Thank you again to all of you, April, Michael, and Anjana. I mean, they're really insightful presentations, and you all bring very specific elements to the fore, and also actually that there is reason for hope, I would say, but it's probably still a long way. So I give you the floor, April, Michael, and Anjana, if you wanted to comment on each other or maybe add this or the other element to your own presentation.
I'm happy to go first.
Oh, please do so, April. Thank you.
Thank you. Yeah, thank you, Michael and Anjana, so much for your presentations. It was really wonderful to hear you both speak. And it's really nice to kind of have the three perspectives of kind of the judiciary, academia, and practitioners. I had a question for you both. I thought I would kick off the kind of discussion session with those. Anjana, I thought it was great hearing about all of those cases, and I wondered how you see cases in the Global South developing going forward, and whether you think, whether you've seen so far or expect to see a stronger emphasis on adaptation or mitigation or both.
Yeah, I think you already, that's a very good question. In fact, I was going to mention about that. But Legari already talks about adaptation and mitigation, and the two cases in South Africa, both, if I may say, both, the Earth Life case and the Philippi case, already are actually talking about adaptation and mitigation. The funny fact is that, the Global South, you have judges saying all the right things, but where is the political will that is going to sort of, implement this? I think the role of the judiciary, as independent as it can be, when you talk about the separation of powers concept constitutionally, you can only go that far, right? The legislature will then have to sort of implement your laws and bring in a policy that will sort of go in tandem with it. So we're exactly at a David and Goliath situation, and I hope that in our situation, David wins, and there have been cases. I won't spread the news of doom. There is hope. We've seen that through many cases in India itself, where the courts have robustly looked, in fact, used comparative methodology and used compensation strategies that have been, given an Exxon Nobel in the asbestos litigation case to sort of go forward. So we're on the path, I would say. Yeah, that's my 2 bits. Yeah. How would you say it? Flipping the question to you, how would you look at it from a perspective after, being so closely involved with Urgenda? How would you look at it for the Global South, not for the Global North? Yeah.
Okay, well, I think particularly in the work that we've done in, I think you just said not the Global North, but just to start off, to set the context, I think that a lot of international organizations may have a bit of a focus when it comes to mitigation on Global North countries, simply because they have more historical responsibility for emissions and they have higher emissions. And there may be a sense that developing countries, perhaps better or worse, may need an opportunity to develop and therefore have a higher amount of emissions, either on an absolute basis or on a relative basis compared to Global North countries. But I am interested to see how and whether that's going to change, because we've definitely heard from national organizations who have been interested in taking mitigation cases against their governments, despite that kind of being a feeling across many international organizations. So I think that cases, of course, need to be led by national organizations and what the feeling is on the ground as to what is needed from their national governments. In terms of adaptation, I'm in a slightly less strong position to be able to comment, because CLN primarily works on framework cases concerning mitigation, but I simply can't see how there aren't going to be a proliferation of cases in that respect, simply because the impacts of climate change are already happening and likely to get, as we know, much worse over the coming decades.
Yeah.
Can I ask Michael maybe to come in and also maybe highlight the role of the judges again, because Anjana just mentioned the separation of power. That's something which is discussed widely, but I think as you have shown, there's really a role for the judges, and it requires certain things like courage, and maybe you could chip in here.
Thank you, Thomas and Anjana. I am very much sympathetic to your understanding that the Global South is neglected in so many ways. And with respect to the rule of law, though, it is important to know what an equalizer the law can be from the Global South. For example, the Laghari case, Justice Mansour Ali Shah is a hero. Pakistan doesn't have that big of a carbon footprint. It certainly isn't that influential in terms of geopolitics necessarily, but wow, that case is important. April, really, how big is the Netherlands? That was one of the arguments in Urgenda. The litigation's ridiculous. It's a little country, it contributes almost nothing. Don't waste our time in the courts with these little cases from little countries. But it makes the point how powerful the rule of law can be, because it was very helpful to us. We're in Hawaii, we have the climate cases, and much of it comes from our experience with Justice Mansour Ali Shah in the Global South. And of course, we're influenced by the Urgenda case, as is our great federal court judge, one of the few federal court judges that was willing to recognize the constitutional right to a life-sustaining climate in our Juliana case, which you all know about. So I'm with you. The Global South can't be neglected in terms of the importance of its magnificent judges. I mean, and you can go to the Philippines too if you're talking about the Oposa case. So with that said, though, whenever there's a discussion with respect to judges, it's healthy for us to use emergency, sui generis emergency. We're not engaged in some sort of decision-making about which court's being treated fairly, which court isn't, which community's being treated unfairly, which court isn't. We have to pay attention, I would submit, not to adaptation. Adaptation is a distraction and a frustration. Right? We have to pay attention to mitigation if we're going to keep the Earth from heating up to 1.5 degrees. So I'm really making the point that we have to look at the science and the facts and make decisions accordingly. And for remedies to be applied in the way that they need to be applied, which is historic, to go along with the historic emergency, there's got to be a political stability, a political support system, which is why Urgenda and Juliana are so important, because the support system that comes from organizing young people, mothers, and indigenous people internationally comes in large part from Urgenda and from Ligari and certainly from Juliana. So I appreciate your points. And from a judge's point of view, I really think the more cases that are focused on mitigation, the better chance we have to protect the planet and protect, human communities.
Thank you so much, Michael, for these insights. I think unless you want to add something, Anjana or April, I'm ready kind of to open the floor to our audience. We had a hand raised. We have also a question in the chat. Maybe I just mention these. So in the chat, we have the question, what about the rights of nature? Maybe you could start thinking about that, April, Michael, and Anjana. And maybe also the question of how to think differently about the law. I mean, how can it take care of the more systemic approach? We have a school which is now developing Earth system law. And while you are considering these questions, maybe I give the floor to Sunaida Musa, who has raised her hand just now. So maybe, Sunaida, would you like to unmute yourself and ask your question?
Thank you very much. And hello from Johannesburg, South Africa. I would just like to begin by complimenting all the speakers. And I have a couple of points for Anjana that I would like to discuss or just, comment with him, and a very important question for Michael, please. So I'll try and be as quick as I possibly can. Anjana, your presentation was really enjoyable on the Global South. And I just want to quote from Judge Shah in the Azgat Ligari case, who referred to the climate crisis by calling for a clarion call. And in South Africa, the same message is reiterated. You raised the point about the definition of climate litigation as set out by the Sapin Center, and which I may add is also used by the LSE Grantham Institute. And the problem with that definition, not fully encapsulating all cases in the Global South, I'd like to just bring to your awareness. We have a case in South Africa dealing with the deadly air. It's called the Vukani deadly air case, deals with the air quality and how that affects people with asthma, for example. So, and also to add on to your discussion, the Earth Life case and the Philippi horticultural case have used human rights issues, and similar to what the first speaker spoke about, the Urgenda case, and how that was the first case to bring about human rights, particularly Article 2 and Article 8 of the European Convention of Human Rights. In South Africa, in the Earth Life and in the Philippi horticultural case, the human rights issue was raised from the specific right to an environment and the specific right to just administrative actions. And these two rights are situated within the Bill of Rights of the South African Constitution, and that gives it the fundamental human rights approach. So just for your information. Thank you. And then, Michael, your contributions have been quite phenomenal. I would like to hear from you, being in Hawaii and being in the global north, particularly in the US, where the largest number of climate cases have occurred. Why, in your opinion, are there no cases for people with disabilities? We have seen vulnerable people, namely women and children, being claimants or applicants in a vast number of cases. And yet, if we look at the 2010 Cancun Agreement, which specifically mentioned that people with disabilities are more severely affected by climate change, and hence their conditions are exacerbated. Why would you particularly think that there is not one single case in which a claimant or in which a judge even talks about, and this goes for both Global North and Global South jurisdictions, in which the judge talks about people with disabilities? And thank you, and sorry for taking up too much of time.
Thank you, Sunaida. So who wants to start? Maybe it was directed first to you, Anjana.
Yeah, it was more of an addendum to what I was saying. So I'm really grateful that you made such great contributions to what I was saying. In fact, I wrote it down in my notes that Philippi and Earthlife both talk about, they look at, someone asked about the right of nature also. They look at all these gamuts of rights as a fundamental, from a fundamental right aspect, and talk about, whether it is a sustainable right of the environment for the present and the future generations, or the responsibility that politicians have to take ahead. I think South Africa is my favorite in the sense of the kind of jurisprudence that comes out of the African nations. I've been also recently following the Ogiek case and the Ogoni case from Nigeria. And again, they talk about the indigenous people's rights without actually mentioning about women. And very funnily enough, the ILO, the Convention for Indigenous People also does not talk about women, and they've just given like a very recent clarification about the effects on women. So I think the cases they don't directly talk about, this is my understanding and I'm subject to correction, they don't directly talk about climate change or the effects or etc. They look at it, I think it's more creative for them to sort of look at it from a constitutional perspective, to then translate it to the legislature and then look at policy impact. This is how I look at whether it's cases coming out of Pakistan, India, South Africa, Philippines, or Brazil. Yeah. Thank you so much.
Thank you, Anjana.
Your insights.
I don't know who wants to come in now, Michael or April?
Well, I'm happy to answer that question, Zunaida, and thank you for asking about why courts in the United States in particular are not addressing the effects of climate change on people with disabilities. And in looking at the framework of litigation in the United States, it's helpful to understand that we have the worst courts in the world when it comes to climate law and the federal courts. Recently, in the West Virginia versus EPA case, one of our great justices on the Supreme Court that unfortunately is in the minority, that's Justice Kagan, described the analysis of the majority as frightening. That's powerful language for a law suit that's at the United States Supreme Court and for a justice to use. Why is it frightening what the United States Supreme Court is doing? Why was it frightening when the Juliana case was reversed by the Ninth Circuit? Incidentally, with a beautiful dissent by a tremendous woman whose name is Josephine Staten, who wrote a now famous dissent that talked about how it was an abdication of the court's responsibility to throw out the Juliana case. And the Juliana case is still alive, incidentally. That's another story. But this is an example of what's happening in our federal courts too. Mainstream cases that are based in large part on an Urgenda type of analysis. And you would never find the Supreme Court of Pakistan doing that with Mansoor Ali Shah, where access is being granted to poor farmers. So we have a very hostile environment from the federal courts of the United States. It's very different in the state courts, as you can see from the decisions that have been made by our court. But the constituency that's struggling in the United States to address adaptation or mitigation or the fraud that's being perpetrated by the fossil fuel industry, the struggle is by a constituency that usually has a certain sympathy, children, future generations. Now, even municipalities like the city and county of Honolulu are bringing the cases. So what is my point about disabilities? It sounds like you're a wonderful advocate for those with disabilities. And so anyone that's an advocate feels they're on the fringe. People with disabilities don't have political power. They're not of great concern to the point in the United States where they're being even taken care of in terms of public benefits. So we do not have the kind of social conscience that Europe has, for example, in providing a kind of welfare network for
Michael, maybe can I come in? We have here Lucy in the chat who would like to elucidate some disability cases, and maybe you can also make a link to socioeconomic rights and climate change litigation. Thank you, Mike.
Sure, thanks, Thomas. And it's been very interesting to sit in the background and listen to all the presentations today. I'm April's colleague from the Climate Litigation Network. And just in relation to the question about what cases are happening globally that are brought by people with disabilities about the impact of the climate crisis. The speaker, the person who made the question is right. There aren't many of these cases globally, but a few examples that you might be interested in looking at. And haven't been any decisions issued yet, but one case brought against the Austrian government was by a man with MS and he described his symptoms as being very temperature sensitive, such that when temperatures reach, I think it's over 25 degrees, his ability to live an independent life massively reduces. And so that case was, he brought it against the Austrian government, challenging their overall efforts to reduce emissions, but particularly because the failure to do that impacts him as someone with a disability disproportionately, even compared to the general population, who we know will all be affected. So there's a real discrimination element happening when states are failing to take climate action. That's one example. That didn't succeed in the Austrian courts, but is now before the European Court of Human Rights. So one of those cases that April is a bigger group. So April mentioned 3 of them, but there's some other cases, and one of them is a disability rights focused case. And that uses the rights that are contained in the European Convention on Human Rights. So right to private and family life, which includes that dignified life and health, is the primary right being used in that case with the discrimination lens. The other one you might be interested in is out of Australia. So a number of First Nations peoples and people with disability in Australia brought a complaint to 3 of the UN Special Rapporteurs about Australia's weak climate action, including because of the impact climate change will have on them as individuals, including due to their disabilities. There was quite a lot of personal statements included in the complaint about the impact that climate has due to extreme weather events, challenges with evacuation, with heat, with all kinds of issues in urban and rural areas in Australia faced by people with disabilities. So that one is not before a court, but it's before a UN mechanism. So that's another example of some kind of climate action being taken there. But I think it's an area where we would like to see a lot more scrutiny of government's actions, because across the board, when there have been studies done of governments' mitigation and adaptation plans, there's very, very little regard for the right to persons with disabilities. And I'll put in the chat a study that was done by academics in Canada that documented government's long-term climate strategies and found just real disregard for any impact suffered by people with disabilities. So they're not being taken into account in the planning process of governments, and that has legal consequences. So I'll pop that in the chat, but I think it's a really important issue. Thanks.
Thank you so much, Lucy. I don't know if you want to comment, April, on this, or maybe also there was a question in the chat on socioeconomic rights and climate change.
I don't have too much to add to Lucy's very fulsome overview of those two cases. I saw a question in the chat about, oh, sorry, there's multiple. I think the first was about the rights of nature. And
yes,
how
exactly. Yeah, you could address this one if you can.
Sure. Again, I probably will keep it pretty short and sweet. As Matthias has identified, it's pretty up and coming movement. I think the most relevant case was one brought against the Colombian government by an organization called Future Generations. And essentially, they were alleging that climate change and the government's failure to reduce deforestation was not in compliance with their net zero deforestation in the Amazon by 2020 pledge. And interestingly, the Supreme Court found that the Colombian Amazon was a subject of rights, i.e., essentially the forest was not granted personhood per se, but was something that could benefit from rights in and of itself, which is a really interesting concept and potentially something that could transfer to other countries. In many countries that I have worked on or kind of contributed to cases on, this is not necessarily something that's easily transferable in some jurisdictions. For example, in the UK, this isn't something that has happened yet, but it's potentially something that could happen in the future, but a really interesting space. And I do wonder as well whether Michael has any thoughts and whether Anjana has any thoughts in terms of whether or not this is something that's transferable in other global South countries.
If I could respond just briefly, April, and thank you for bringing up the Colombia case. It was written by one of the great contemporary justices of our time, Louis Tolosa. The idea of the rights of nature, the extent to which places that have great cultural and natural resource importance to different countries and to different jurisdictions is definitely a robust idea, that you would give the rights of, shall we say, an individual to certain locations in nature. Well, you know, the analogy that's helpful, I mean, in the United States, we give the power of the individual to corporations, right? So this is a really important analogy to make, because that kind of personhood has been abused in the United States. And so the rights of corporations have transcended even the rights of individuals to a certain extent when it comes to things like campaign financing. So I will mention that to say, I think if you look forward, if we do continue to have a healthy rule of law in 50 or 100 years, this will be a developed area of the law, just like, you know, for human rights, we no longer buy and sell people. For human rights, the idea that women would be treated equally was completely irresponsible and not something that would be adopted by any modern society. And now the rights of women are something that are fundamental, I think, to justice throughout the world. So I really consider this to be an area of the law that can't get too much attention. And the more that it is addressed by academics and creative litigants, the sooner it will become one of the signature aspects of a robust environmental law of the future.
Thank you, Michael. There's one question by Catherine Booth. She raised her hand. Maybe we can hear you, Catherine, before we wrap up.
Yes, can you hear me?
Yes, we can.
Okay, great. I'm trying to turn my camera on. Yeah, so my name's Catherine Booth. I work for OECD Watch, which is a network of civil society organizations, and we focus on complaints against companies. So using these standards for companies, and I was actually just now on a call led by OECD Watch because these standards have been really strengthened in terms of climate change and environmental harms. So we as a network are now pushing and encouraging civil society to use these standards, file complaints against companies, and basically get them to reduce their greenhouse gas emissions, reduce their environmental harms, mitigate, prevent environmental harms. So I'm just wondering is there a hierarchy of when we file complaints against governments compared to when we file complaints against companies? Yeah, because I entirely focus my work on complaints against companies currently, and increasingly climate complaints.
Okay, great, Catherine. Just for the sake of the procedure here, we are coming close to 6:30, but we still have a question also from William Spence. So I would totally understand if people would go, and also maybe some of our presenters need to go. So I would like to take the opportunity to thank you all, April, Michael and Anjana, and also Lucy, who has come in to share her thoughts and bring some input on disabilities and people with disabilities and their rights. But having said that, I'm happy to extend this a little bit for those who want to stay on. But I would totally understand if people want to go. But thank you so much for these very insightful presentations, and we continue with the questions. So maybe you could answer Catherine Booth's question if you wanted, or if you can, in terms of the hierarchy of adjudication.
I'd be happy to answer that quickly, Catherine. I can't resist answering it because it's such a wonderful question. Look, we're in a time when there is an injustice that's almost surrealistic. In other words, you can't imagine it. In the United States, we are under the control. We have great influence from the most powerful industry that pollutes that we've ever seen. The degree of pollution that's taking place is so extreme that it's created to a certain extent the careers of the people on this call. I mean, it's amazing to think we're increasing fossil fuel emissions and we are using government money, trillions, to subsidize the private sector that is causing the problem. So the way to inject injustice into this unjust system is to bring lawsuits like David versus Goliath. You have the slingshot in your hand. You can go directly to the power interests that are going to lose their power soon. They can see it coming. They can't continue to poison the atmosphere in a way that's consistent with the rule of law. It just isn't going to happen. So when you define the fiduciary duty, it's remarkable that you have a fiduciary duty that not just accepts, it endorses this idea that we're going to invest in fossil fuel in the future. We have subsidies that take state money and allow the fiduciary duty to be celebrated as, my goodness, if you make $200 billion in profit, a record profit, are you complying with your fiduciary duty? You are practically the emblematic poster child for the fiduciary duty because the profit that you're making, it is something that could be considered scandalous and is over and over and over again in the media. But we need your cases to be able to let judges, some that have the courage to stand up to that kind of corporate power, which is unprecedented, have the judges recognize this is an absolute violation of a fiduciary duty. And the ecocide concept gives it a supercharged nature. When you are going against the individuals who are perpetrating this level of injury at a global level and putting them in jail, then you will use the rule of law in a way that might allow us to create the transformational change that's necessary. So I'll conclude by saying you have put your finger on transformational change. When young people bring a lawsuit, they're not that politically powerful, and they're asking for remedies that are going to come from government in large part. When they bring a tort action directly against the fossil fuel industry, or you bring your cases based on fiduciary duty or claims against businesses, then you've got the David slingshot. You have a chance to create enormous transformational change at the corporate culture that now is essentially in control of, in many ways, the COP process. And as Barack Obama says, the traditional governance systems that right now are not working to create justice for future generations. And so thank you for bringing up that question. Good luck with your claims against business.
I was also hoping to come in on this question. I unfortunately need to dial off after I answer, but yeah, thank you so much for bringing up the question. In terms of there being a hierarchy, and in my view, I don't think there necessarily is one. Cases against governments and cases against companies can be very synergistic and very complementary. And, you know, whether it's more strategic to bring a case against one of the other is going to be highly dependent on what's happening at the national level. But just to give an example, if you're to take a case against a government, by forcing the government to try and adopt additional measures or proper frameworks, regulatory frameworks, legal frameworks, there's a kind of underlying assumption here that those regulatory frameworks will apply to companies. I mean, ultimately, one of the benefits of taking a case against a government is that you may ultimately end up with more stringent laws and regulations under which you can take cases against companies. And then also, as Michael says, it's definitely an emerging area of law that governments or individuals are taking tort-based claims against companies, and that's also something that can happen simultaneously. I think that the more cases that are successful, the more likely it is that you can have cases against both companies and governments, and that hopefully together we can end up with a solution that's kind of working at the national level, but in terms of multinational companies working at the international level to try and have outcomes that are positive internationally.
Thank you so much, April. Yeah, if you have to dash off, thank you for your presentations, April and Lucy. And yeah, we continue to wrap up this one. Maybe at this point, I see Stephen as coordinator. Would you like to come in, or Deborah?
I would only say thank you very much to everybody, and thank you also to you, Thomas. Thomas really was one of the big pushes behind getting this panel together, and I'll turn over to Stephen.
You're muted, Stephen.
Thanks. It's not surprising, given the quality of these speakers and the importance of the topic, that we've gone a tiny bit over time, but every minute of it was riveting as far as I'm concerned. You did a spectacular job of managing this, and the speakers, aloha over there, and of course my neighbor here, who may well be, you may have seen the handkerchief up and so on. This is related not only to seasonal illnesses, but probably also to the current state of the environment in the Delhi region. But this is probably the most important challenge we have facing international human rights in the context of sustainable development. And I couldn't have imagined a better panel for this. So thank you so much. Let's keep at it, keep moving, and do more of this. And thank you very much, Thomas, for chairing.
Well, thank you all, and for your fantastic presentations. There is Suming Ko, who wants to quickly come in. or maybe not, maybe it's just...
No, I was just clapping.
Oh, I see. Yes.
Clapping
Thank you
from-
so much, Suming. And thank you, Matthias, also for your clapping. And thank you all for your questions. It's really made this a wonderful panel. And thanks again for the presenters. I really appreciate all your insights you brought to the table. And I think it's really this kind of knowledge which will help us hopefully to make progress in the future. Thanks so much.